Indian polity and governance, current affairs, prelims 2023. Secularism. Secularism deals with relationship of state with the religious identity of its citizens. Secularism in the Western world is thought to be as separation between states and religious affairs. Indian model of secularism, despite maintaining a separation from religious affairs, maintains a positive relationship with religious aspects. Slow. Thus, Indian Constitution allows state to positively engage with the religious aspects, which is called a theory of principled distance. A secular state may keep a principled distance from religion to promote peace between communities. It may also intervene to protect rights of specific communities. Rule of law. Rule of law means absolute supremacy or predominance of regular law as opposed to influence of arbitrary power, and excludes existence of arbitrariness or even wide discretionary authority on part of government. Procedural aspects. Independent and impartial courts to settle disputes. Right to representation by counsel. Supremacy of law. Nobody can be punished else for breach of law. However, in a constitutional democracy, the laws enacted should just fair and reasonable. In India, doctrine of basic structure ensures that judiciary can overturn enacted legislation, including constitutional amendments, if they are not fair and reasonable. A.V. Dicey's theory of rule of law. Law is supreme or supremacy of the law. Equality before the law. Predominance of legal spirit. Federalism. Symmetric federalism. Powers of position of all constituting units are similar. Asymmetric federalism. Powers and positions of all constituting units are not similar. For example, in India, different states have different position in Lok Sabha and Rajya Sabha. Concept of union territories. Concept of special powers, such as in Article 371A to Article 371K, display asymmetric nature of Indian federalism. Quasi-federalism, a term used by K.C. Where for Indian federalism. This meant that Indian federalism has features of unitary government UK and federalism USA. Equality. Rights of different social groups of people to have a similar social position and same treatment. Absence of privileges. Preamble. We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty, liberty of thought, expression, belief, faith, and worship. Equality of status and opportunity. Fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Preamble is inspired from objective resolution introduced by Jawaharlal Nehru in Constituent Assembly. The vision given in the preamble of our Constitution is the guideline for ensuring the spread and reach of the political, economic, and social democracy in the country. The words socialist, secular, and integrity were added by Constitution 42nd Amendment Act SSI. Social, secular, and integrity. by the 42nd Constitution Amendment Act. Amendment. I'm sorry. The preamble has been amended only once so far. The preamble has been amended only once so far. Preamble does not grant any power, but it gives a direction, purpose to the Constitution and also outlines its objectives. The preamble contains the fundamentals of the Constitution and serves the following important purposes: contains the enacting clause which brings the Constitution into force, declares the rights and freedoms intended for its people, declares the basic type of government and polity which is sought to be established in India, throws light on the course of the Constitution with the people of India. Source of Constitution are the people themselves, from whom Constitution derives its ultimate sanction. The people of India thus constitute the sovereign political body who hold the ultimate power and who conduct the government of the country through their elected representatives. Is the preamble part of the Constitution? Preamble was added after rest of the Constitution was already enacted. Supreme Court in Berubari Union Case 1960 said that the preamble in not the part of the Constitution. However, in the Keshavanandi Bharati case 1973, the Supreme Court overturned its previous decision and held that preamble is a part of Constitution and can be amended under Article 368. In the S.R. Bommai case, the Supreme Court held that preamble indicates the basic structure of the Constitution. Preamble indicates the basic structure of the Constitution. Fundamental rights basics. The fundamental rights in the Indian Constitution have been grouped under the following heads: General, Article 12 to 13, right to equality; 14 to 18, right to freedom; 19 to 22, right against exploitation; Article 23 to 24, right to freedom of religion; Article 25 to 28, 25, 26, 27, 28, cultural and educational rights; 29 to 30, right to constitutional remedies; Article 32 to 35. Puttaswamy judgment on privacy. Right to privacy as an integral part of right to life and personal liberty as guaranteed under Article 21 of the Indian Constitution. Privacy is the constitutional core of human dignity. Privacy has both a normative and descriptive function. At normative level, privacy subserves those eternal values upon which the guarantees of life, liberty and freedom are founded. At descriptive level, privacy postulates a bundle of entitlements and interests which lie at the foundation of ordered liberty. Privacy includes preservation of personal intimacies, the sanctity of family life, marriage, procreation, sexual orientation and right to be left alone. Privacy protects heterogeneity and recognizes the plurality and diversity of our culture. Issues related to 5th and 6th schedule. Demand for 6th schedule. MP from Ladakh has demanded inclusion of Ladakh in the 6th schedule of the for constituting autonomous district council which is elected for a period of 5 years. Union Territory of Ladakh has 2 hills councils in Leh and Kargil, but neither is under the 6th schedule. 6th schedule. Schedule 6 of the Indian Constitution provides for the scheduled and tribal areas. Article 244 class 2 under part 10 provisions of 6th schedule shall apply to administration of tribal areas in the states of TM, Assam, Meghalaya, Tripura and Mizoram. Autonomous districts. Tribal areas in the states of Assam, Meghalaya, Tripura and Mizoram shall be declared as autonomous districts. Autonomous regions. If there are different scheduled tribes in an autonomous district, the governor may by public notification divide the area of areas inhabited by them into autonomous regions. District council. There shall be a district council for each autonomous district consisting of not more than 30 members, of whom not more than 4 persons shall be nominated by the governor and the rest shall be elected based on adult suffrage. Regional council. A separate regional council for each area constituted as an autonomous region. Restricted powers of district council. In an autonomous district with regional councils, a district council shall have only such powers with respect to areas under authority of regional council as may be delegated to it by regional council in addition to powers conferred on it by this schedule. Legislative powers of district council or regional council: make laws related to land or forest other than any land which is a reserved forest. Use of any canal or watercourse for agriculture. Regulation of shifting cultivation. Regulation of shifting cultivation, JHUM. Establishment of village or town committees or councils and their powers and any other matters such as town police, public health, primary schools. Inheritance of property of marriage and divorce according to social customs. Tamil Nadu CM highlights in issues in Indian federalism. Chief Minister of Honorable Tamil Nadu, Honorable Chief Minister of Tamil Nadu flagged concerns on the kind of federalism practiced by the central government. Federalism is a system of government in which the power is divided in between a central authority and various constituent units of the country. Dr. B.R. Ambedkar stated that India is a union and not a federation of states. India is a union and not a federation of states. The states have no right to secede from the union. The federation is a union because it is indestructible. The federation is a union because it is indestructible. Sariga palugura. Indestructible. Okay. Concerns on federalism practiced by the center. GST Council taking away states' autonomy of taxes. Dismantling Planning Commission which used to grant discretionary grants to states for specific purpose. Non-flexibility to states in admission through NEET. Forceful adoption of 3-language formula by center including mandatory learning of Hindi in schools. Delay in release of grants by center despite submission of utilization certificates by states. Steps towards electronically friendly judiciary. Live streaming of Constitution Bench cases. In Swapnil Tripathi versus Supreme Court, full court meeting of the Supreme Court decided to live stream all Constitution Bench proceedings of Supreme Court from September 27, 2022. Swapnil Tripathi versus Supreme Court 2018. Supreme Court accepted in principle the idea of live streaming cases of public importance. Live streaming would virtually expand the court beyond the four walls of the courtroom. Appropriate rules to be framed under Article 145 of the Constitution of India. SC observed sunlight is the best disinfectant. SC observed, Supreme Court observed sunlight is the best disinfectant. Live streaming of court proceedings will effectuate the public right to know and bring in more transparency in judicial proceedings. Certain prohibitions on live stream. Cases falling under the following categories shall be excluded as a class from live streaming. Matrimonial matters, matters involving interest of juveniles or protection and safety in the private life of the young offenders. Matters of national security, to ensure that victims, witness or defendants can dispose truthfully or without any fear. Special protection must be given to vulnerable or intimidated witnesses. It may provide for face distortion of the witness if she or he consents to the broadcast anonymously. To protect confidential and or sensitive information, including all matters relating to sexual assault and rape. Matters where publicity would be unethical to the administration of justice. Cases which may provoke sentiments and arouse passion and provoke enmity among communities. What is e-prisons? The e-prisons application suite integrates all the activities related to prison and prisoner management. It provides vital information about the inmates lodged in the prisons in a real-time environment to the courts, prison officials, and other entities involved in the criminal justice system. It facilitates online visit requests and grievance redressal. It facilitates online visit requests and grievance redressal and grievance redressal. About e-prison project, the e-prisons project of Ministry of Home Affairs aims at computerization of the functioning of prisons in the country, including digitization and availability of prisoners data, convicts, undertales, detainees, etc. in an electric platform which will be accessible to designated authorities of central and state governments. E-prisons project will help in creating a centralized standard information database. E-prisons uses data maintained by the states and union territories on the National Prisons Information Portal as per protocols notified for e-prisons. Components of e-prison project: e-prisons management information system MIS, management information system used at the prisons for the day-to-day regular activities. The major models of e-prison: MIS prisoner information management system, visitor management system, hospital management system, legal aid management system, inventory management system, prison management system, police intelligence system, court monitoring and kiosk information. Doctrine of basic structure. Doctrine of basic structure. Basic structure doctrine was expounded in landmark judgment of Kesavananda Bharati case. Basic structure of constitution cannot be altered or amended by the parliament or executive. Basic structure is not exclusive list and things can be added by judiciary in future in the list of basic structure. Things can be added by judiciary in future in list of basic structure. Basic structure cannot be altered or amended by parliament or executive. Elements of basic structure: supremacy of the constitution, republican democratic form of government, secular character of constitution, separation of powers between legislature, executive and judiciary, federal character of constitution, mandate to build welfare state contained in the DPSP, directive principles of state policy, sovereignty and unity and integrity of the nation, essential features of the individual freedoms, judicial review, Minerva Mills judgment example, secularism, SR Bommai case example. Salient features of Representation of People Act. Salient features of Representation of People Act 1950 and 1951. Article 320, Article 324 to 329 of Part 15 of the Constitution deal with the electoral system in our country. Constitution allows Parliament to make provisions in all matters relating to elections to the Parliament and state legislatures. In exercise of this power, the Parliament has enacted laws like Representation of the People Act 1950, RPA Act 1950, Representation of the People Act 1951, RPA Act 1951, and Delimitation Commission Act of 2002. Delimitation Commission Act of 2002. Representation of People Act, Qualification of Voters. Representation of People Act 1951, Qualifications and disqualification for conduct of elections. Representation of People Act 1950, Preparation of electoral rolls, delimitation of constituencies, allocation of seats in the Lok Sabha and state legislatures, powers and functions of district election officer and chief electoral officers, constitution of electoral colleges for filling of seats in the Council of States allotted to Union territories. Representation of People Act 1951, Qualifications and disqualifications for conduct of elections, notification of general elections to Lok Sabha and state legislative assemblies, administrative machinery for conduct of elections, role of important election officers, returning officer, observers, filing of nomination papers and scrutiny by returning officer, election offences, addressing election disputes, conducting by elections. Registration of political parties, cap on election expenses by individual candidates, regulating election agents of political parties, regulating election agents, fixing time for poll and cancel poll in case of emergency, counting of votes and declaration of results, security of EVMs and VVPATs. One not second Constitutional Amendment Act, National Commission for Backward Classes NCBC. Article 338B creates a Constitutional Commission for the socially and educationally backward classes to be known as National Commission for Backward Classes. Composition shall consist of chairperson, vice chairperson and 3 other members. Conditions of service, tenure of office of the chairperson, vice chairperson and other members to be determined by President by rules. They will be appointed by President by warrant under his hand and seal. Functions of the NCBC: investigate and monitor about safeguards provided for SCBCs under COI or under any law or order, also to evaluate working of above safeguards, inquire into specific complaints with respect to deprivation of rights and safeguards of the SCBCs, participate and advise on socio-economic development of SCBCs and to evaluate the progress of their development under the union or any state, present annual report to the President and other reports as the Commission deems fit upon the working of safeguards, make recommendations about the measures that need to be taken by the union and or states or the effective implementation of safeguards and other additional measures for socio-economic development of SCBCs in the above reports. President shall lay all reports of NCBC before each House of Parliament along with memorandum explaining the action taken, the reasons for the non-acceptance of any such recommendations. NCBC will have the power of civil court while inquiring into any complaint. Union and state governments to consult NCBC on all major policy matters affecting the SCBCs. Article 342A, President, after consultation with the governor of each state or UT, Union Territory, to notify SCBCs for every state or UT. Central list of SCBCs, Parliament can law include in or exclude from the central list of SCBCs. Special Officer for Linguistic Minorities, Article 350B. There shall be a Special Officer for Linguistic Minorities to be appointed by the President. Article 29 provides that any section of citizens residing in Indian territory shall have right to conserve distinct language, script or culture of their own. Duty. It shall be the duty of the special officer to investigate all matters relating to the safeguards provided for linguistic minorities under this constitution and report to the president upon those matters at such intervals as the president may direct. The president shall cause all such reports to be laid before each house of parliament and sent to the governments of the state concerned. Indian Army can get exemption from RTI. Indian Ex-Services League, an association of ex-servicemen, family pensioners and next of kin of the KIN of the armed forces personnel has written to PM Narendra Modi against exempting Indian Army from RTI Act, Right to Information Act. Reasons for request. RTI helps to maintain transparency in the functioning of the Indian Army. RTI acts as a powerful tool for family members of serving officials and veterans to seek information from the governments or to seek documents or service records of army officials. RTI Act helps to address myriad grievances of army personnel and their family members regarding service issues on pension matters. It has been observed that seeking information through RTI has reduced litigation in court. Section 8 and 9 of RTI Act provides adequate protection for sensitive information which the army do not want to disclose. Section 24 of RTI Act exempts certain central investigative agencies. The provisions of the RTI Act shall not apply to the intelligence and security organizations specified in the second schedule of the Act. However, information pertaining to allegations of corruption and human rights violations shall not be excluded of such central investigative agencies. Information about allegations of violation of human rights shall only be provided after the approval of the Central Information Commission. Such information shall be provided within 45 days from the date of the receipt of request. Central government by amendment may add or omit any intelligence or security organization from the second schedule. Such amendment shall be laid before each house of parliament. Aspirational District Program. United Nations Development Program UNDP India has lauded Aspirational Districts Program as a very successful model of local area development that should serve as best practice for several other countries where regional disparities in development status persist for many reasons. Aspirational District Program. Transformation of Aspirational Districts Program aims to expeditiously improve the socio-economic status of 117 districts from across 28 states. The three core main principles of the program. The three core principles of the program are convergence of central and state government schemes, collaboration among citizens and functionaries of central and state governments including district teams, and competition among districts. Driven primarily by the state, this initiative focuses on the strength of each district and prioritizes the attainable outcomes for immediate improvement. Districts will be ranked on their incremental progress through delta ranking. Districts will be ranked on their incremental progress through delta ranking. Aspirational Districts Program through real-time monitoring and proactive course corrections reinforces the mechanism of operative and competitive federalism between central and states down to the districts. Niti Aayog has entered into partnership with Tata Trust and Bill and Melinda Gates Foundation ID Insight to assist the districts in enumerating improvement in key performance indicators through household survey. Focus themes. Aspirational District Program. The program focuses on 5 main themes which have a direct impact on quality of life and economic productivity of citizens. Themes: health and nutrition, education, agriculture and water resources, financial inclusion and skill development, basic infrastructure. Basic infrastructure. Paharis as a scheduled tribe. Paharis as scheduled tribe. Gujjar and Bakerwals are opposed to G.D. Sharma Commission's recommendations to include Paharis in ST list. Pahari community. Pahari community includes Hindus and Muslims and is largely based on the language spoken by them in the hills. They largely reside in Rajouri, Poonch, Baramulla, Anantnag and Kupwara districts. Although the Gujjar, Bakerwal tribes and Pahari community are born in the same social and cultural milieu, and the former Gujjar Bakerwal live a nomadic life, shuttling between Kashmir and Jammu regions with their livestock, while the latter Pahari are socially stratified, economically well off and culturally moved with caste and other ethnic divisions. And Rajouri in Jammu and Uri of Baramulla district, and Karna and Tangdar in Kupwara district. Scheduled tribes. Framers of constitution realized that certain communities in the country were suffering from extreme social, educational and economic backwardness on account of the primitive agricultural practices, lack of infrastructure facilities and geographical isolation. Constitution of India in Article 366 Clause 25 prescribe that scheduled tribes mean such tribes of tribal communities are deemed under Article 342 of the Constitution to be scheduled tribes. Article 342 Clause 1. The President may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof, by a public notification, specify the tribes or tribal communities are part of or groups within tribes or tribal communities as scheduled tribe. Article 342 Clause 2. Parliament may by law include in or exclude from the list of scheduled tribes prepared through presidential notification any tribe or tribal community or part of or group within any tribe of tribal community. Based on Article 342, Parliament enacted the Constitution Scheduled Tribes Order 1950, which contains a list of tribes or groups designated as scheduled tribes. This order is amended from time to time, include more groups of communities with the scheduled tribe fold. Criteria to designated as ST. The criteria presently followed for specification of community as a scheduled tribe are indications of primitive traits, distinctive culture, geographic isolation, shyness of contact with the community at large and backwardness. Right to Information Act 2019. The Right to Information Amendment Act 2019 changes the terms and conditions of service of the CIC and Information Commissioner of the Central and in states as mentioned in RTA 2005. RTA Amendment Act 2019. The amendment provides that the appointment will be for such term as may be prescribed by the central government. The amendment provides that the salaries, allowances and other terms of service of the Chief Information Commissioner and the Information Commissioner shall be as may be prescribed by the central government. The amendment has removed the equivalence of CIC with that of CEC. This makes the CIC vulnerable to be removed by the central government, as CEC can only be removed on the same manner as that of judge of the Supreme Court. The amendment provides that these appointments should be for such term as may be prescribed by the central government. The amendment proposes that salaries, allowances and other terms of service of the State Chief Information Commission SIC, State Chief Information Commissioner shall be such as may be prescribed by the central government. The equivalence of State CIC and that of Election Commissioner and State Information Commissioner with the Chief Secretary of State stands removed on salary. By amending Section 27, the central government controls the terms and conditions of appointment of commissioners in the states. Food Safety and Standard Authority of India FSSAI. FSSAI has been established under Food Safety and Standards Act 2006. It operates under Ministry of Health and Family Welfare. It operates under Ministry of Health and Family Welfare. Mandate frame of regulations to lay down and enforce various standards and guidelines in relation to articles of food. Lay down mechanism and guidelines for accreditation of certification bodies engaged in certification of food safety management system for food business, including accreditation of certifying laboratories. Provide scientific advice and technical support to central government and state governments in the matters of framing the policy and rules in areas relating to food security and nutrition, and also check for adulteration. Collect collate data regarding food consumption incidents and prevalence of biological risk, contaminants in food residues of various and contaminants in foods products, identification of emerging risk and introduction of rapid alert system. Creating an information network across the country so that the public, consumers, panchayat, etc. receive rapid, reliable and objective information about food safety and issues of concern. Provide training programs for persons who are involved or intended to get involved in food businesses. Contribute to development of international technical standards for food, sanitary and sanitary standards. Promote general awareness about food safety and food standards. National Commission for Protection of Child Rights. National Commission for Protection of Child Rights, set up in 2007 under Commission for Protection of Child Rights Act 2005. Works under administrative control of Ministry of Women and Child Development. The Act provides for constitution of National Commission and State Commissions for Protection of Rights and Children Courts for providing special trial of offences against children or of violation of child rights. The Commission shall consist of a chairperson and 6 members, out which at least 2 shall be women. The child is defined as a person in the 0 to 18 years as age group. 0 to 18 years. Appointment. Central government shall appoint chairperson and other members. Chairperson shall be appointed on recommendation of a 3-member selection committee headed by Ministry of Women and Child Development. Function. Examine and review the safeguards provided for the protection of children under various laws and recommended measures for effective implementation. Inquire into violation of child rights and recommend initiation of proceedings such cases. Examine all factors that inhibit the enjoyment of rights of children affected by terrorism, communal violence, riots, RIOTS, natural disaster, domestic violence, HIV or AIDS, trafficking, maltreatment, torture and exploitation, pornography and prostitution, and recommended appropriate remedial measures. Look into the matters relating to the children in need of special care and protection, including children in distress, marginalized and disadvantaged children, children in conflict with law, juveniles, children without family and children of prisoners, and recommend appropriate remedial measures, study treaties and other international instruments, undertake periodic review of policies and programs, and promote research in the field of child rights. Lokpal and Lokayukta. Idea to constitute two-tier Lokpal and Lokayuktas was first proposed by First Administrative Reform Commission. As per the proposal, Lokpal should deal with complaints against ministers and secretaries of central government as well as in the states. The Lokayukta, one for the center and one for each state, should attend complaints against the rest of the bureaucracy. Each government department should have suitable machinery to receive and investigate complaints and set in motion the administrative process to provide remedies. The Lokpal may either act on the complaints made by an affected citizen or on his own cognition. He shall investigate cases related to maladministration involving acts of injustice, corruption and favoritism. The investigations and proceedings should be conducted in private and should be informal in character. If there are criminal charges against a public official, he can bring it to the notice of Prime Minister or Chief Minister, or they can set the machinery of law in motion and inform the Lokpal. Lokpal and Lokayuktas Act 2013. The Lokpal and Lokayukta Act 2013 establishes Lokpal for the Union and Lokayukta for states to inquire into allegations of corruption against certain public functionaries. A complaint under the Lokpal Act must pertain to an offence under the Prevention of Corruption Act against a public servant. When a complaint is received, the Lokpal may order a preliminary inquiry by its inquiry wing or refer it for investigation by any agency, including the CBI, if there is a prima facie case. Thus, the Act provides for an inquiry wing and a prosecution wing headed by their respective directors. The inquiry wing conducts a preliminary inquiry into any offence alleged to have been committed by a public servant punishable under the Prevention of Corruption Act 1988. The prosecution wing can file a case in accordance with the findings of investigation report before the Special Court for prosecution of public servants in relation to any offence punishable under the Prevention of Corruption Act 1988. Jurisdiction of the Lokpal Act includes offices of Prime Minister, ministers, members of Parliament, officers belonging to Group A, B, C and D, and officials of central government. Commission on Official Language, Article 344. The official language of the Union shall be Hindi in Devanagari script. Appointment. President shall at the expiration of 10 years by order constitute a commission which shall consist of a chairman and other such members representing the different languages specified in the 8th schedule as the President may appoint. Duty of Commission to make recommendations to the President. Progressive use of Hindi language for official purposes of the Union. Restrictions on the use of the English language for all or any of the official purposes of the Union. Language to be used for all or any of the purposes mentioned in Article 348. Language to be used in Supreme Court and in every High Court. English language. Form of numerals to be used for any one or more specified purposes of Union. Any other matter referred by the President to the Commission regarding official language of the Union and the language for communication between the Union and a state or between one state and another state and their use. In making the recommendations, the Commission shall have due regard to the industrial, culture and scientific advancement of India, just claims and interests of persons belonging to non-Hindi speaking areas about the public services. Committee. There shall be constituted a committee consisting of 30 members, of which 20 members shall be members of the House of the People and 10 members shall be members of the Council of States, to be elected by each House in accordance with the system of proportional representation by means of the single transferable vote. The committee shall examine the recommendations of the Commission and report to the President their opinion. Reservation in promotion, note of fundamental right. Reservation in promotion, note of fundamental right. Reservation in promotion in public posts cannot be claimed as a fundamental right. As per the recent Supreme Court judgment under Article 16 Class 4 and Article 16 Class 4A, judgment of Supreme Court. Article 16 Class 4 and Article 16 Class 4A empowers the state to make reservation in matters of appointment and promotion in favor of the scheduled caste and scheduled tribes if in the opinion of the state they are not adequately represented in the services of the state. Article 16 Class 4 and Article 16 Class 4A are in the nature of enabling provisions, and accordingly state has discretion either to provide reservation in public services under Article 16 Class 4 or reservation in promotions under Article 16 Class 4A, or not to provide such reservations. If the states wish to provide reservations in promotion, then the state has to collect quantifiable data showing inadequacy of representation of that class in public services. Even if under representation of scheduled castes and scheduled tribes in public services is brought to the notice of the court, the state cannot be directed to provide such reservations under writ of mandamus. Supreme Court effectively held that state government is not bound to make reservations, and citizens cannot claim reservation in public services under Article 16 Class 4 and reservation promotion under Article 16 Clause 4 as fundamental right. Constitution 105th Amendment Act. The Constitution 105th Amendment Act present by Article 338B, 342A and 336 Clause 26C allows the states and union territories to prepare their own list of socially and educationally backward classes. The Constitution 103 Act 2018 inserted 3 new articles 342A, 33626C and 338B in the Constitution. Article 338B constituted the National Commission for Backward Classes. Article 342A dealt with the central list of the socially and educationally backward classes, commonly known as other backward classes. Article 36626C defined the socially and educationally backward classes. Constitution 105th Amendment states the and union territories to prepare their own list of socially and educationally backward classes. This list must be made by law and may differ from the central list. Article 338B of the Constitution mandates the central and state governments to consult the NCBC on all major policy matters affecting the socially and educationally backward classes. The amendment exempts states and union territories from this requirement for matters related to preparation of their list of socially and educationally backward classes. Attorney General and Advocate General. The Advocate General shall hold office during the pleasure of the Governor and shall receive such remuneration as the Governor may determine. Advocate General. Okay. For Attorney General, Article 76, President appoints highest law officer of the Union Government, eligible to be appointed as Judge of Supreme Court and holds office during the pleasure of the President. Advocate General. Article 165, Governor appoints highest law officer of the State Government, eligible to be appointed as Judge of the High Court. Holds office during pleasure of the Governor. Attorney General eligible to appointed as Judge of Supreme Court. Attorney General remuneration decided by Government. Advocate General remuneration decided by the Governor. Duties and functions of Attorney General: advise GOI on legal matters, represent GOI in courts, perform other legal duties assigned time to time by President. Privileges of Attorney General: right to audience all courts in territory of India, attend parliamentary proceedings, speak and take part in the proceedings of the committee. No right to vote. Right to private practice. Criminal case prior permission from the government. Okay. Duties and functions of Advocate General: advise concerned state government, represent concerned state, legal matters referred by Governor. Privileges: audience within the territory of the state, Article 177. Similar position in state legislature. Understanding office of profit. Article 102 and Article 191 of the Indian Constitution provides that a person shall be disqualified from being chosen as a member of Parliament or state legislature if he holds an office of profit under the state or central government. An office of profit means an extra position within the government which brings some financial gain or advantage or benefit or perks apart from the public they currency hold. Thus, to comprise office of profit, it has to be an office under the appointment of government, and benefits, perks, salary and financial gain must be released from public exchequer. However, holding certain offices will not incur this disqualification as per the Parliament Prevention of Disqualification Act 1959. The Act has listed certain offices of profit under the central and state governments, holding of which does not disqualify MP or MLA under office of profit. Supreme Court on office of profit. The Supreme Court of India in various judgments has elaborated the following points to determine whether any MP, MLA or MLC holds office of profit or not. If the appointment has been made by government, if the government had the right to remove or dismiss those holding such office, if the government pay the remuneration, are these functions performed any different from the one of the member already performs, if the office holder perform these functions for the government, if the government exercises any control over the performance of those functions. Supreme Court held that if answers to any of these questions are in the affirmative, then the person concerned can be said to be holding office of profit. Opinion of Election Commission mandatory. It is mandatory for the President and the Governor to act according to such opinion as provided by Election Commission in case of disqualification on grounds of office of profit. Joint Committee of Parliament on Office of Profit. It consists of 15 members, 10 from Lok Sabha and 5 from Rajya Sabha, who were elected from amongst the members of the respective houses according to the principle proportional representation by means of single transferable vote. Functions of Joint Committee on Offices of Profit. Examine the composition and character of all committees, membership of which may disqualify a under Article 1 or 2 of the Constitution. Recommend in relation to the committees examined by it officers should disqualify and what officers should not disqualify, and scrutinize the schedule of the schedule to the Parliament and schedule the Parliament Prevention of Disqualification Act 1959 from time to time. Anti-defection and merger. The High Court of Bombay and at Goa in its judgment held that the former members of the Congress legislature party in the Goa Assembly who had defeated to BJP are exempt from disqualification under paragraph class 4 class 2 of Constitution's 10th schedule. The court said that under subparagraph class 2 of paragraph 4, the merger of this group of Congress MLAs with the BJP is deemed to be a merger of the original political party Congress with the BJP. Therefore, these members are protected under paragraph 4. Important highlights of 10th schedule. Disqualification of elected and nominated members. Both elected and nominated members of parliament would be disqualified on the grounds of defection if he or she voluntarily relinquishes his membership of such political party or votes or abstains from voting in such house contrary to any direction of such party or is expelled from such party. Paragraph 4. Disqualification on grounds of defection not to apply in case of merger. The merger of the original political party of a member of the house shall be allowed only if not less than 2/3 of the members of the legislature party concerned have agreed to such merger. Paragraph 5 of 10th schedule. A person who has been elected to the office of the Speaker or the Deputy Speaker of the House or the people of the Deputy Chairman of the Council of States or the Chairman of the Deputy Chairman of the Legislative Council of a State or Speaker or the Deputy Speaker of the Legislative Assembly of a State shall not be disqualified under this schedule. Okay. Public trust doctrine. Public trust doctrine is a traditional common law doctrine rooted in English and Roman law that has for over a century served as a limit on government power over natural resources. The doctrine limits government and private individuals' authority to use and transfer of public trust resources when doing so would interfere with the purposes of which the resources were held in trust. Doctrine serves two purposes: mandates affirmative states action for effective management of resources, empowers citizens of question ineffective management of natural resources. Any sovereign authority cannot transfer public trust properties to a private party if such transfer of natural resources would interfere with public interest. Important case: Span Motel case, MC Mehta versus Union of India. Lok Adalats. Legal Services Authority Acts lay down a framework for Lok Adalats. Every state authority or district authority or Supreme Court Legal Services Committee or every High Court Legal Services Committee or Taluk Legal Services Committee may organize lok adalats. Every lok adalat organized for an area shall consist of such number of serving or retired judicial officers and other members as may be prescribed by any of the respective authorities. A lok adalat shall have jurisdiction to determine and arrive at a compromise settlement between the parties to dispute in respect of any case pending before or any matter which is falling within the jurisdiction of and is not brought before any court for which the lok adalat is organized. Lok adalat shall have no jurisdiction in respect of any case or matter relating to an offence not compoundable under any law. Non-compoundable cases are serial criminal cases which cannot be quashed or compromise is not allowed between the parties. It is always registered in the name of a state. Example, State of Karnataka versus XYZG. Under a non-compoundable offences, full trial is held which ends with the trial, acquittal or conviction of the offender based on the evidence presented in a court of law. Functions of Lok Adalat. Lok Adalat, while hearing a case on summon and enforce the attendance of any witness, examine him or her on oath, make discovery of documents, receive evidence, ask for requisitioning of any public record or document or copy of such record or document from any court office. Lok Adalat can specify its own procedure for the determination of any dispute. All the proceedings before a Lok Adalat shall be deemed to be judicial proceedings. Awards of Lok Adalat. Every award of the Lok Adalat shall be deemed to be decree of a civil court or an order of any other court, and where a compromise or settlement has been arrived. Every award made by Lok Adalat shall be final and binding on all the parties to the disputes, and no appeal shall lie to any court against the award. E-Court Mission Mode Project. The E-Courts Mission Mode Project Phase 1 2010 to 2015, Phase 2 2015 to 19 is a national e-governance project for ICT enablement of district and subordinate courts of the country. The major objectives of the project are to make whole judicial system ICT enabled by putting in place adequate and modern hardware and connectivity, automation of workflow management in all courts, electronic movement of records from taluka or trial appeal or to appeal courts, installation of video conferencing VC facility and recording of witness through video conferencing, connecting all courts in the country to the National Judicial Data Grid NJDG through WAN and additional redundant connectivity, citizen-centric facilities such as electronic filing, e-payment and use of mobile application in all courts, touchscreen based kiosks in each court complex, full computerization of state and district level judicial and service academies and centers. Special Officer for Linguistic Minorities, Article 350B. There shall be a special officer for linguistic minorities to be appointed by the President. Article 29 provides that any section of citizens residing in Indian territory shall have right to conserve distinct language, script or culture of their own. Article 29. Duty to investigate all matters relating to the safeguards provided for linguistic minorities under this constitution and report to the President upon those matters at such intervals as the President may direct. The President shall lay cause all such reports to be laid before the Parliament and sent to the governments of the states concerned. Suggestions made by Parliamentary Committee on Languages. Division of states into region A, B and C states for use of Hindi language. The committee has advised that Hindi be granted a respectable place in A category states and be used completely. States under region A includes Bihar, Haryana, Himachal Pradesh, Madhya Pradesh, Chhattisgarh, Jharkhand, Uttarakhand, Rajasthan and Uttar Pradesh and the Union Territories of Delhi, Andaman and Nicobar Islands. Region B includes Gujarat, Maharashtra, Punjab and the Union Territories of Chandigarh, Daman and Diu and Dadra Nagar Haveli. Region C, other states where the use of Hindi is less than 65% are listed under region C. Region C. Objection by Khasi Hills Autonomous District Council. Khasi Hills Autonomous District Council KHADC has objected to the settlement between the governments of Assam and Meghalaya as consent of the council was not taken. The deal remains to be ratified by Parliament and the assemblies of two states concerned before the boundary is redrawn. Claim of KHADC Khasi Hills Autonomous District Council. Section 41 of Right to Fair Compensation and Land Acquisition and Rehabilitation and Resettlement Act 2013 makes prior consent mandatory. The provisions highlights that no acquisition of land shall be made in scheduled areas unless prior consent of the concerned Gram Sabha, Panchayats, Autonomous District Councils at the appropriate level in scheduled areas under the 5th schedule to constitution is obtained in all cases of land acquisition in such areas. 6th schedule of the constitution provides for creation of autonomic district council. Each of them functions as a government within a specified territory. Administration of scheduled areas and tribal areas. Article 244. Provision of 5th schedule shall apply to the administration and control of scheduled areas and scheduled tribes in any state other than the states of Assam, Meghalaya, Tripura and Mizoram. AMTM. Part 10 of the Indian Constitution provides for the scheduled and tribal areas. Article 242 clause 2 under Part 10 provides that the provisions of 6th schedule shall apply to the administration of the tribal areas in the states of Assam, Meghalaya, Tripura and Mizoram. Currently there are 10 such councils in the region Assam, Meghalaya, Tripura. Assam 10 councils. Bodoland Territorial Council, Karbang Anglang Autonomous Council, Dima Hasao Autonomous District Council, Meghalaya, Garo Hills Autonomous District Council, Jaintia Hills Autonomous District Council, Khasi Hills Autonomous District Council, Tripura Tribal Areas Autonomous District Council, Chakma Autonomous District Council, Lai Autonomous District Council, Mara Autonomous District Council. Rationally for Constitution 125th Amendment Act Amendment Bill. 125th Constitution Amendment Bill aims to amend Article 280 of the Constitution to enable Finance Commission to recommend measures need to augment consolidated fund of the states to supplement resources of autonomous councils, village councils and municipal councils and constitutes State Finance Commission in 6 scheduled areas. Rename existing autonomous district council, increase number of seats in district councils, provide for reservation of at least 2 seats for women in district councils, transfer additional subjects to Karbi Anglang and Dima Hasao autonomous territorial councils, conducts elections to all autonomous councils by State Election Commission, providing for disqualification of elected members on account of defection. Section 7. Integrated communications technology. Internet and communications technology. Artificial intelligence. AI or artificial intelligence is the science of making machines perform tasks that require human intelligence. AI includes activities such as learning, reasoning and self-correction. It allows machines to learn from experience, adjust to new inputs and perform human-like tasks. AI, artificial intelligence versus computers. While computers rely on instruct, fetch, execute cycles, AI enables machines to sense, comprehend and act. It is based on symbolic, non-algorithmic processing and relies on heuristic to identify patterns and relationships. AI used for speech recognition, text analysis and vision. It includes technologies like machine learning, pattern recognition, big data, neural networks, self algorithms, etc. Internet of Things (IoT). Internet of Things is a seamlessly connected network system of embedded objects or devices with identifiers in which communication without any human intervention is possible using standard and interoperable communication protocols. Internet of Things is extension of internet connectivity into physical devices and everyday objects. Embedded with electronics, internet connectivity and other hardware like sensors, these devices can communicate and interact with others over the internet. They can be remotely monitored and controlled by computers and smartphone. Web 3.0. Web 3.0 is the next version of the internet where services will run on blockchain. It is a decentralized internet that runs on a public blockchain which is also used for cryptocurrency transactions. It will be permissionless and democratic. For instance, Twitter will not be able to censor posts and Facebook will not be able to maintain a database of billion of users that can be potentially used to influence elections. In a Web 3.0 universe, people will control their own data and will be able to move around from social media to email shopping using a single personalized account, creating public record on blockchain on all the activity. Tim Berners-Lee, inventor of World Wide Web, intended that internet would be a collaborative medium, a place where all meet and read and write. But the current situation is entirely opposite, with the big tech companies acting as gatekeepers to all that on World Wide Web. Space weaponization, anti-satellite technologies. Satellites form an integral part of a country's critical infrastructure. Intercepting satellites can halt various critical applications including navigation systems, communication networks, broadcasting, banking systems, surveillance, etc. What is a ASAT? Anti-satellite technology is a counter-space capability of a country to neutralize space-based assets of enemy country. Types of ASAT: missile-based ASAT, anti-satellite technology. A missile is used to hit and destroy satellite using direct ascent kinetic kill vehicle. Chinese ASAT in 2017. India now, USA and Russia. Co-orbiting missile. Russia has this type. Co-orbiting missile. Russia has this type. Co-orbital drones approach the target satellite and deviate it from its orbit. China, UK, Russia are working on this technology. High energy lasers blind the sensors of the satellites. Interception and jamming of signals from the satellites by sending more powerful radio signals. History of anti-satellite technology missile tests have been conducted by USA and Russia in the Cold War era. USA has the anti-satellite weapon since 1959, followed by Russia in 1960. The Cold War witnessed the anti-satellite weaponry tests till early 1980s. China conducted ASAT weaponry test in 2007, 800 km orbit. Russia has recently shot down satellite using ASAT weaponry as lately as October 2018. AWACS, Indian AWACS, AWACS. Indian Air Force has undergone a doctrinal shift from conventional warfare to sub-conventional warfare due to threats from proxy wars by Pakistan's deep state post. Thus, India identified key operational requirements of IAF in the aftermath of Balakot airstrike, one line with the counter-proxy war strategy. AWACS are one of the short-term operational requirements identified by IAF. What are AWACS? Known as the eyes in the sky. Airborne radar systems mounted on aircrafts for scanning and surveillance, with a 360-degree span that are deployed to carry out surveillance on enemy air defense systems and to prepare on air situation picture useful in aerial combats. Current fleet on AWACS in IAF. India currently has 5 AWACS AWACS. Falcon AWACS procured from Israel. AWACS procured from Israel. Defense technology, missiles in of India, cruise missile and ballistic missile. Cruise missile. A cruise missile is a guided towards a present land-based target using a navigation system. Ballistic missile. A ballistic missile is generally a projectile shot up in the atmosphere. Ballistic missiles are launched outside the atmosphere where its warheads detach and hit the targets. Uses gravity of Earth and thus traces a parabolic path and hence the name. Um, Cruise missile have short ranges from short ranges of 300 to 1000 kilometers. BrahMos nearby BrahMos 290 to 450 kilometers nearby 700 to 700 to 1000. Easy to intercept because of high terminal speeds. Cruise missile high precision due to navigation system. Cruise missile cheaper and thus suitable for firing conventional warheads. Cruise missile. Ballistic missile have long ranges up to 1000 kilometers. ICBMs Agni V 5000 kilometers. Difficult to intercept due to high terminal speeds of 5000 meter per second. Low precision ballistic missile. Expensive and thus suitable for firing nuclear warhead. Ballistic missile. Hydrogen important for prelims 2023 to 2024. Okay, why hydrogen? A general trend towards development of better fuel is hydrogen rich fuels. This means more of hydrogen in the fuel and less of carbon and or more hydrogen to every carbon atom. Example, natural gas for hydrogen to every carbon as opposed to very little hydrogen in coal. This is because just like carbon, hydrogen is also combustible, that is, it mixes with oxygen in the air and gives heat. In addition, moving from a solid to a liquid and then finally to a gaseous state, energy carrier. Natures of hydrogen. Hydrogen as an energy carrier. It is important to understand that all fuels we have seen so far are energy carriers. Hydrogen is the best energy carrier as there are no harmful impact. This is because hydrogen is not freely available on earth, but it is abundance in the form of in water and hydrocarbons. However, to extract hydrogen from water or hydrocarbons, you need to expend energy, and the energy spent in extracting hydrogen is much more than the amount of energy the so extracted hydrogen gives out. This is why hydrogen is energy carrier and not energy source. In fact, all fuels we have seen are energy carriers. Sequestration. Pressurize the CO2 and put in beneath the earth surface. There are different strategies depending on where below the earth surface you pump and store the CO2. Geosequestration. NISAR planned launch late 2023 early 2024. Joint active remote sensing satellite of NASA ISRO, thus all weather day and night cloud penetrating. Short for NASA ISRO synthetic aperture radar satellite. Two radar frequencies S band and L band. Uses advanced technique called interferometric synthetic aperture radar. INSAR superimpose multiple reflected light beams to cause interference, helping in construction of 3D topographic maps. Time series images of such topographic maps help in observing surface motion and change. Hakuto, or Japanese private company iSpace, world's first private sector mission to moon lander mission. It has already reached the moon's orbit as of March 20. As of orbit as of March 20. As of March 20. Black hole. What is a black hole? Black holes are just one-way geometric surfaces like mirrors created by gravitational collapse due to high gravitational field. Once you go towards it, there is no way you can come out of it. Not like doors, which are two-way surfaces. You go in and come back. The area surrounding black holes are massive, high in gravitational field and violent. Inside the black hole, nobody knows what is going on. There are supermassive black holes in middle of galaxies, including Milky Way, which has a black hole that is formed out of core of mass equal to 3 billion solar mass. A supermassive black hole is the one whose mass is millions to billion times the mass of sun. We have seen how black holes are formed in the dying stage of a star's cycle. A dying star leftover core having more than 3 times the mass of the sun undergoes a gravitational collapse, leading to the creation of a black hole. As the star's matter becomes compressed to enormous densities, the strength of gravity at the surface of the rapidly contracting star also increases dramatically. According to the general theory of relativity, this massive contracting star has a profound effect on the space-time immediately surrounding the star. While the space-time surrounding the black hole becomes so highly curved that it closes on itself, black hole itself is a place in space-time where there is a collapse of gravity. Test series చేద్దాం.